means the chairman is more equal than anybody else. These, like I've said, and I repeat again, are just flower girls and page boys. That surely cannot be the intention, could not have been the intention of people who drafted this constitution. We go back to where we started from, and I've said that in my original submissions. Where did we come from? We need to know where we came from. One-man show? Surely that cannot be the issue. The other issue that the Chief Justice asked everybody, and that's where my client, that there were all these problems, these commissioners had walked out, the transparency, accuracy. Nobody has given us that answer as we sat through this today. You specifically asked, Madam Chief Justice, why was it not declared that there were these problems, 27 constituencies? Nothing. We couldn't do it because there was a problem. I don't want to go into Maina Kiai case, but you were quoted paragraph 287 of the Supreme Court, which I called RAILA, which was RAILA 1 or 2. But please, before just looking at 287, please look at paragraph 292 of this court's decision. I don't want to repeat it, but this court specifically said, it is in my original submissions, we fault the appellant, who was the IEBC, and the chairman, who was the current chairman, for there being no verification by the commission. We've been told we've misread the section because it's polling stations. With due respect, if it was going to be only polling stations, why send it to the National Tallying Center? It is for the public to know there were mistakes here, there were no mistakes, whatever else there was. A question was asked by the court yesterday. Why did the running tallying stop? Nobody's given us an answer. All the difficult questions that we were to get answers for, to which my client, as a voter, and as Wanjiku, I keep on saying, we have not received any answers whatsoever. No affidavits. In fact, the sad part is, despite this whole matter being consolidated, we were considered the surrogates. Nobody sent us any papers to sign. I have two requests from this court, as I have said, and this was what I was thinking of last night before I went to bed. Where it is established that a state officer is subverting the Constitution and the rule of law, the court's hands are not shackled by procedural niceties. This is the beauty of this Wanjiku Constitution that we have. It's transformative, and some people say it's a very overused word, but in these circumstances it's ideal and can bite when occasion demands. The toothless bulldog is long dead and buried. Please, Madam Chief Justice and honorable judges of this court, bite and bite for the glory of this court. And in closing, whilst we said, we were told our petition is much ado about nothing, and like I said, we've really been battered, but we shall soldier on. I will use Martin Luther King's words, because I suppose, unlike Professor Guido Muigai and Mr. James Orengo, I went to a school where they didn't teach us Shakespeare, they taught us Things Fall Apart. They went to the posh schools. And all Martin Luther King said in 1968, at the speech given at the National Cathedral, we shall overcome because the arc of the moral universe is long, but it bends to justice. That's all we request. Can we have justice for all of us, for the voters? Because the two parties just think about themselves. They forget us, who are the voters. Thank you. And I donate my 4 minutes back to the court.
Thank you. We will have the third petitioner, Youth Advocacy Africa, and Peter Kirika.
Madam Chief Justice and Madam Deputy Chief Justice, and may it please the members of the court. Yesterday, and for a section of this morning, Your Ladyship, I believe we've been allocated 30 minutes. I see the clock says 15. The directions clearly said 30 for us. Youth advocacy.
I don't know whether there was any question directed to you.
Yes, there were. But the direction said 30 clearly.
No, the directions I have.
Yes, for youth.
Yes, for youth advocacy is 30 minutes.
30 minutes, yes. I think the clock said 15.
Yes.
I was a bit concerned, yes. But for yesterday, for most of yesterday and this morning, members of the court.
Sorry, Counsel.
Yes.
For our record.
Yes.
Introduction.
Yes, Your Lordship. My name is Tom Asharia. I appear together with my colleagues on record for Youth Advocacy Africa and Peter Kireka. Most of yesterday and this morning, you are treated to the theory of an election as it ought to be conducted. My colleague, Julie Soweto, has demonstrated to you what every Kenyan knows. Mambo kwa ground ni different. I call your attention to the affidavit yesterday presented by my good and learned friend, Professor Kindiki, which has been projected. It's the affidavit of Veronica Ndwati. She deposed that she is the Secretary General of United Democratic Alliance and was the Deputy Chief Agent for the 9th and 10th respondents. In particular, I call your attention to paragraph 7, where she states that the verification process went through a 3-tier mechanism. At paragraph 7, she says the second tier was at the constituency level, where the following actions were undertaken. She then goes to subparagraph C, and that is the one of interest here, and this is what she says. In case of any errors, this is at the constituency level, on Form 34B, the same would be corrected. That is the key. Those are the key words. She then goes on at paragraph 8 and says that the third tier was at the National Tallying Center at Bomas of Kenya, where the following activities took place. We go to paragraph 8F. The verification team would also verify that each of the uploaded Form 34A in the public portal is a replica of the original 34A presented by the constituency returning officer, and in instances of discrepancies, the errors were noted. She then says at G, the team would also verify that the data entered in the IEBC online system for purpose of tallying from all original forms was correct. In case the data entered in the IEBC online system is incorrect, the same was corrected on the online system. She then goes at J, a verified Form 34B would thereafter be generated at Bomas. Another one, having corrected at constituency, another one now is generated at Bomas and supplied to the candidates' agents. I specify these particular provisions because, members of the Honorable Court, this is precisely what the chairman of IBC was told in the minor KI case he could not do. And it bears reading because, as has been repeated here severally, and perhaps I shouldn't repeat it too many times, he is qualified to be a Supreme Court judge. And so we know he understood minor KI. So it is important that we understand what he did not understand about the following passage. It is evident, I'm reading from minor KI, it is evident to us from the above sequence of events that the role of the chairperson of the appellant is circumscribed. Article 138 deals with events at the polling stations where votes are counted, tallied, verified, and declared. The appellant, that's the commission, as opposed to its chairperson, upon receipt of prescribed forms containing tabulated results for election of president, electronically transmitted to it from near 40,000 polling stations, is required to tally and verify the results at the National Tallying Center without, this is the key word, without interfering with the figures and details of the outcome of the vote as received from the County Tallying Center. Minor KI states further, the chairperson, on the other hand, is appointed under Article 250 of the Constitution. The chairperson cannot be and is not the commission. It goes on to say, and I say this because my good friend George Morogo this morning told you that whether the chairman is the commission or the chairman is a matter of context. It is not a matter of context. Maina Kiai put that debate to rest once and for all. And finally, to suggest that there is some law that empowers the chairperson of the appellant as an individual to alone correct, then that's the word, correct, vary, confirm, alter, modify, or adjust the results electronically transmitted to the National Tallying Center from the constituency tallying centers is to donate an illegitimate power. Such a suggestion would introduce opaqueness. These were the words used by the 4 commissioners who disagreed with what was going on at Bomas. Opaqueness and arbitrariness to the electoral process, the very mischief the Constitution seeks to remedy. I don't know how much clearer it can get that what the chairman of the commission did was the very opposite of what the Constitution required him to do. Now, Maina Kiai was itself based on several decisions of this court. The first of those being Wanjohi, which is a 2014 case, and it is cited there, where the court said, apart from the priority attaching to the political and constitutional scheme for the election of representatives of governance agencies, the weight of the people's franchise interest is far too substantial to permit one official or a couple of them, including the returning officer, unilaterally to undo the voter's verdict without having the matter resolved according to law by the judicial organ of state. The only organ under our constitutional framework permitted to correct at any level, let alone any of the 3 levels that the chairman of the commission undertook, is this court. It is manifest to this court that an error regarding the elector's final choice, if indeed there is one, raises vital issues of justice such as can only be resolved before the courts of law. We reiterate as we conclude that there is no doubt from the architecture of the laws we have considered that the people of Kenya did not intend to vest or concentrate such sweeping and boundless powers in one individual, the chairman of the appellant. Now, as we stated, the chairman is an eminent lawyer, qualified to be a Supreme Court judge. It is extremely unlikely he did not understand what Maina Kiai had told him. And the only reason he would then have proceeded in the manner that Veronica Nduati tells us is that, to use another Kenyan phrase, mtadu, what are you going to do about it? That is the only reason one can find for what he did. Yesterday, the commission came and told you that the system was accessed thousands of times by officers at the Bomas. And so clearly, you had returning officers, specific special returning officers, assigned to changing forms on the portal, as has been demonstrated this morning. In our submission, the alterations made to this system, to the forms, these so-called corrections that were done at 3 levels, so alterated and contaminated the outcome of the election that it is now incurably defective and incapable of being rescued. Now, we were challenged to demonstrate from their own forms what the problem was with the forms. Now, time doesn't permit me to take you directly to those affidavits, but the Commission has filed an affidavit through the firm of Iseme Kamau and Maema in our petition, the affidavit of Esther Wanjiko Wanjohi. She attaches 14 forms. That's about a quarter or 30% of the forms that you asked to be taken through the scrutiny. Of those 14 forms, 8, representing 57% of the forms, 8 have irregularities, have gaps, have problems, including the fact that when you read them with a QR code, the serial number that shows up is for a different polling station. The problems are correction problems, tallying problems on those forms submitted by the commissioners themselves, by the commission itself. You have an affidavit submitted again by the commission, the affidavit of Nzika Mwololo. Same problems. He has two forms. 50% of them, which is one form, has an incorrect addition where the rejected votes have been added as part of the total. Now, in light of what Mainakia has said and what my learned seniors have said here this morning, my mind is taken back to a few months ago when a few of my colleagues here, my good friends here, came before this court and told you and persuaded you that a process known as BBI, one where 1 million signatures had been collected, one which had gone through over 40 county assemblies, one which had gone through both houses of parliament, was irredeemably void and null because the president used the wrong process. And they persuaded you. And I invite you to look at paragraphs 1544, 1535, and 1500 of your judgment in the BBI case, where you stated that any process, any activity undertaken without constitutional authority, as the chairman of the IBC has done in this particular case, must be declared null and void. And the terms null and void, and this is one of the cases we've stated before you, the case of McFoy versus United Africa Company, is captured in the following words. If an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have a court declare it to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. That is the fate, the Form 36, the Form 34D, issued by the chairman of the commission in this matter, must suffer as well. Now, my learned friend, Mr. Mahat, has taken you through some numbers. And as I've demonstrated, and as was demonstrated earlier here by my colleagues for the first petitioner, when you have a process where the numbers are so adulterated, where the forms are so compromised, what numbers are we talking about? Numbers that have been verified or quote-unquote tallied in an unconstitutional matter. Our learned senior, I think Mr. Orengo, I think it was Otinde Amolo Senior Counsel, said that the numbers became a moving target. Now, in fact, they were behaving not more like a moving target, but like a group of naughty children in a nursery school running around the yard. It is impossible to get a hold of the number that was used either for the 50+1 or for the tallying or for the verification, which, as you have heard, was changed 3 times. Now, you asked, I think, of the petitioners, how did we get to this place? Like every slow train crash, a train crash in slow motion, those of us who lived through the repressive days that led to the Constitution of 2010 will tell you that it did not happen one day. My good friend, Mr. Morogo, has told you that the Gazette notice by which the chairman appointed himself as the presidential returning officer. And we need to note, because the defense put here yesterday by the commission, was that he appointed himself on the basis of your judgment in 2017, where in passing, you said that there is a national returning officer. Now this year, he has upgraded. He upgraded himself to presidential returning officer. Now you've been told that Gazette notice means nothing. And I think yesterday you were told we ought to be grateful to him because he had the good grace to publish in the Gazette his unconstitutional appointment. Now, whether you publish misconduct in the Kenya Gazette or you publish an offense does not imbue you with some sort of value, or does not imbue that process with some good grace or quality if the Constitution does not permit that office to exist or does not permit him to conduct himself in the way he did. A Gazette notice does not improve it. But perhaps more importantly, if it meant nothing, why publish it in the first place? If it meant nothing, why publish it at all if it meant nothing? But the point I wish to make is this. Complaints were raised. I think I've seen letters written by the party that nominated the first petitioner. There were newspaper articles complaining, Gazette notices, newspaper notices complaining that ballots had come without commissioners being told, but you'll get to hear that a bit more. There were complaints made by civil society. But as happened with Kenya, when we ended up in the position we ended up before the 2010 Constitution, we keep pushing these things away to the back of our mind. And people go to campaign, the rest of us go on with our lives, and he publishes a new gazette. I am now the presidential returning officer. He goes on ahead and does other things, allocates duties. You go look after flowers, you go be an usher. These are slowly and then progressively, we end up with what was this morning called an imperial chairman of the commission. And so this is how we ended up at this unhappy day, where 4 commissioners say that we cannot stand by these reasons because we were not involved in everything that was done with them. But apart from that, and apart from those obvious misdemeanors and indiscretions that have been pointed out here this morning and the day before yesterday, in our petition, we've raised the fact that even other statutory requirements, the KPMG audit report, for example, was only published on the 5th of August, 4 days to the election. And parties kept asking for this report. Why is the report? And we'd all be told, again, in that most Kenyan fashion, tunashughulikia hiyo maneno. So you go back and campaign, go do your things, and you wait. And on the 3 days before the election, it is dumped on the website, and no one is actually told. There was no press release saying, we've released KPMG now. We had to find it there by accident. Now, when you finally go and look at that report, and you'll see a copy of it in the particular pages I refer you to, pages 1,153 and 1,155 of the petition, you will find that KPMG complains that both the Commission and Smartmatic withheld critical information as regards how the voters' register was being accessed, and that by the time the report was written and released, they had not received that information. That was the KPMG report. Now, again, the Commission comes here this morning and tries to explain to you how they arrived at the question of voters identified with the printed register. One of the things you will not find in the affidavits filed by the Commission is an account of how many Form 32As were signed as required by law. And that is the only mechanism that the regulations identify for identifying those who have voted outside the KIMS kit system itself. And so what they've done, and that's what I think one of the honorable judges yesterday called a bit of a lecture here yesterday, is do reverse mathematics. You begin by adding up all the votes you say were in the Form 34C, and then you subtract from that those who were identified using the KIMS kit. You have not been given a report of how many Form 32As were signed. In addition to that is the tortured question of Regulation 69, Subregulation 1A. And I've not had anything said about that here. Now, Regulation 69(1)A of the Election General Regulations requires that every time a voter is identified using the KIMS kit, the printed register must be crossed out. And this is not a function of voter identification. This is an audit tool to ensure there's no fraud. A distinction must be made between what was before the Court of Appeal, in the case raised before you about the printed register, and what the law requires as regards the crossing out. For some reason, the Commission strenuously opposed these audits too. Now, you've been told that there were approximately 92,000 stray ballots. Now, the mathematics that the Commission chair uses to arrive to that number, for starters, is not an accountable figure. What they've done, and you'll find that, I think, at paragraphs 73, 74, 75, and 76 of the chairman's replying affidavit in our petition, is taken two constituencies, this is Makadara and Kibra, and said that in those two constituencies, we had an average of 2 stray ballots per polling station. They take an average. And the reason for this is that it is not possible to account for stray ballots in Kenya within the time that this court must rule. Because under Regulation 81E, once stray ballots have been identified, they are put in an envelope, and neither Form 37B, 38B, or 39B have anywhere to indicate stray ballots. They are indicated in a polling station diary. The only way of arriving at a precise number of stray ballots and identifying to whom they strayed, if I may use that word, is to audit the polling station diaries for the 46,000 polling stations in this country. And that hasn't been done. And so we can't speak with any certainty here when a figure is thrown at this court that there are 96,000 or 92,000 stray ballots. No one knows. The truth is that no one knows. That's number one. The second thing is that in arriving at these mathematics, the chair of the commission says that in six polling stations in Starehe and Mathare, the officer locked up the forms in the ballot box. And he then says that in the 6, we cannot account now for 4,200 ballots. Now, 4,200 divided by 6 is 700. What he's saying is that in those 6 polling stations, there was a 100% turnout. You will see that at paragraph 74, 75, 76 of the replying affidavit. Now, when you go to the forms on the portal, as we've been asked to do, the turnout is not 100%. And so that is a false averment in his affidavit. I think much has been said about the forms and the PDFs. I think I won't venture to say anything about that. I think I should also state, because it was part of our petition, that by the time we went to the election, and I think as of today, an audit report as required by the elections technology regulations has not been provided or done. It's not on their website, it's not been provided. The elections technology regulations under the Elections Act require an annual audit under Regulation 10 and 11. You will find in a response by the chairman to the first petitioner's party a letter where he says, we could not do the audit because we did not have money. He has now annexed, in response to our petition, a certificate, a 2-page certificate, where they say we have 10 reports, but he doesn't attach those 10 reports. They are not on the website, and we have not been provided with them as of today. The purpose of that audit is that it might become impossible or unnecessary for us to spend time here discussing things called logs. And the only logs my grandmother knows are those she uses to warm herself. And yet she's the voter. We must, and I think we've submitted before you a case from the German Constitutional Court, which states that unless the public is able to, independent of an expert, audit the process used to conduct an election, then that election is not verifiable. That decision is before you with our digest of authorities. And it speaks to something a bit more nefarious, if I may use that word. We have just been told here today that we had foreigners who have accessed our IT systems. I can't pronounce their names on account of my county of origin. Now, and what has happened is that, and the submission I would make, is that the IEBC ceded control of the process of determining the sovereign will of the people of Kenya to a foreign entity that now says that that data is the intellectual property and cannot be shared with Kenyans. And there are very, very serious questions that arise. And I say this because they were asked of the chairman of the commission. For example, this data, they now say is theirs. Has it complied with the Data Protection Act? Was this company subjected to the provision of Section 31 of the Data Protection Act? And what are the consequences of surrendering our data, our biometric data, to foreigners who now tell us that is now their intellectual property? And I think Kenyans would be forgiven for saying that we're going soon to have leaders made in Venezuela, not in Kenya, not by Kenyans. Allow me to use the few minutes left to address some of the questions I think you raised, especially as regards remedies. But before that, let me just point out that amongst the other failures by this commission was to provide the Parliament of Kenya with amended regulations, which they promised to do last year, but presented amended regulations in June or July as Parliament was going on recess Sinai. And so again, they'll come and tell you the law was not amended for us to rectify some of these things, but they submitted their proposals late again and outside the election operations plan that they had said they would do. Now, printing of ballot papers, a specific question was asked of them. This company that you have procured, rightfully or wrongly, is accused of having led to the postponement of an election in Nigeria. And the chairman again said, there's no problem, tunashughulikia hiyo maneno. On the 8th, we have the largest postponement of elections in the history of Kenya. The elections postponed on 8th August was the largest number of postponements in the history of Kenya. So what should we do? Kenyans who run into problems and who find complicated issues they don't know what to do with, I always want to say, do something. Can somebody do something? Somebody should do something. That is what we say. But this honorable court has the power to do something. And it has power to do something even in the face of an imperial commissioner, chairman of the commission, who quite casually says, Mtadu, do something. You have power under Article 140, and again, in my view, I think the question was asked here about the utility of Section 80, subsection 4 of the Elections Act. Now, I think given the time limitations that this court has to do a recount and a retally properly, that section is one that is not very helpful or useful. The requirement of the Constitution under Article 140, sub-article 3, is for a nullification of an election that is found not to have been in compliance with the Constitution. That is number one. Number two, I think the judges asked of us, what is to happen if we are to then find that this chair violated the Constitution or committed crimes? Again, that is a question that has risen here before. I think in 2017, we have an Election Offences Act. We have Article 251, which make provision for what is to happen to errant and imperial officers, public officers, such as the one whose case is before the court today. And so I think it would be premature to start anticipating what were to happen, because I think our Constitution has sufficient, and I think we must trust it. We must trust our Constitution and the mechanisms it has created under Article 140 and other articles for what is to happen in that eventuality. Madam Chief Justice, Deputy Chief Justice, I want to thank you for the privilege of your attention. And unless there are any questions left for me, I will donate my 1 minute back to the court. Thank you very much.
Thank you. 15 minutes given to the fourth petitioner, Kerif Khalifa.
My Lady Chief Justice and the court, may I plead with the court once again that what we are listening to is not a reply. It is a rehash of the case afresh, and it is leaving us in a very vulnerable position because new issues are being raised, and we have had, or may not have, unless you assure us, my lady, that we will have an opportunity to reply.
I think we have already cautioned counsel to reply on points of law, and you can see all of us are busy. We know what are points of law in our reply, and we know what we ignore.
Madam Chief Justice, only 2 seconds. You said that earlier. We all thought we had. Despite that, Mr. Mashari has taken 30 minutes to argue factual issues, going to affidavits, nothing on a point of law that he responded to. In my submission, therefore, the court will be perfectly entitled to disregard every word he uttered.
Yes, we know how to separate the chaff from the wheat, from the submissions. Yes.
My Lady, before I start my submission so that my time doesn't run, I find myself in the position, I'm Willie Sotieno for the fourth petitioner, in the unfortunate position that I'm one of the most mistreated petitioners in these proceedings by the first and second respondents. They served me late, as I indicated already during the pre-conference, and we lost the opportunity to respond. And this court did indicate that when we'll be doing our response, we can comment on some of those issues. We never filed a rejoinder to them because we were the ones who were served late outside the timelines provided by the court. So, but I don't intend to go deep into facts, but I may make one sentence references just to meet what had been allowed before, if that is in order. Number one, my lords and my ladies, we must assert that the KPMG report, the only expert report that has been done on the biometric voter register, that evidence has not been challenged by any other expert evidence. And that evidence which we annexed and we referred to, we can now safely conclude that the 481,711 deduplicates that are in that report, 481,711 is admitted. The second point that I wish to respond relates to the question my learned senior Professor Gidu Muigai said, that if these elections were badly conducted, not in accordance with the law, what about the other 5-tier elections where we have governors and senators? One answer, jurisdiction. Every court will have its day, every court will consider the facts of those cases. The third point that I wish to respond to relates to what was asked of when the regulations that gave the chairman the power to be a returning officer were passed, they were law at the time he acted. Simple answer. Maina Kiai case had already answered that question of what the law was. Maina Kiai case had interpreted Article 138(3)(c) of the Constitution. That was the law, and any regulation being made to circumvent that law by itself is unconstitutional. As I said, Helef was a petitioner in Maina Kiai case. Helef came to court. Helef has come back to court to enjoy the fruits of his litigation in Maina Kiai case, and I was his proud lawyer in that particular case as well. My lords and my ladies, reference was made that the IBC saw the ballot boxes for the first time that necessitated the postponement of the elections on the 8th of August. My lords and my ladies, Lycos never disappoints. You've just been told how Lycos, wherever they've printed ballots, they've always ended up with postponed elections. IBC should have exercised due diligence to make sure that even the pre-printing images are cross-checked and confirmed to be accurate. An admission that I submit is that IEBC was not diligent and it must pay that penalty. It cannot transfer the consequences of their lack of diligence on the people of Kenya through fake elections. My learned friend, Mr. Gumbo, spoke on technology, and he gave us the Kriegler report. Kriegler report did not say deploy weak and vulnerable technology. Kriegler report required you to deploy sufficient, efficient, integral technology that protects the will of the voter. Kriegler report did not make a recommendation for Jose Camargo, Diego Maradona midfielder, to sit in the middle and start distributing results, as was demonstrated today in the morning. Kriegler report is not an answer or does not excuse a technology that the KPMG audit report has found and confirmed to be vulnerable, has 14 unauthorized users called Embakasi South clerks. The fourth point I want to raise is IEBC has confirmed that we look at the portal to tally the results. It is not the public portal that is used to tally. Tallying is a function of the commission. The commissioners must perform a tally of those results. And what is the commission vis-a-vis the secretariat? I refer this court to the case of Engineer Michael Kamau versus EACC, where the court specifically said the core functions of a commission cannot be performed by the secretariat. That was the Court of Appeal decision. It's part of the bundle of documents that we've annexed. You are told, my lords and my ladies, when in relation to the question of how integral the technology was, and my learned that Justice Lenaola did ask, when you take a JPEG and it comes out as a PDF, and I tie it to the response, what Camargo was doing in the system, and my learned friend Samane said, he's a plumber. He's like a plumber maintaining the system. Let me say this. Once a plumber has fixed your bathroom, that plumber has no business being in your bathroom when you are showering. If you find him at that time, you tell him, get behind me, Satan, as was said in the book of Mark 8:33 in the Bible, when the devil entered Peter, and Jesus told him, get behind me, Satan. A plumber who is in your bathroom when you are showering after fixing your shower is no longer a plumber, is a sexual offender and should be reported.
Let's stick to the...
I'm guided. Mr. Somane took you through several forms, explanations, trying to explain what is voter turnout, the Kim's kit. At the end of the day, when you leave, are you able to answer the constitutional threshold, the question, are those results, is that system of technology simple, verifiable, and accurate? Why the many explanations? Why the kizungu mingi? It should be simple, accurate, and verifiable. What we've been shown is not simple, is not accurate. This court is still left with so many questions as to the true Kim's kit logins, as to the true and exact turnout of voters as at 5 p.m. on the 9th of August. You are told that parties must have their own agents to present things here. My petitioner is not a political party. He is not a candidate, but is a voter entitled to participate in elections and to present a petition. The obligation, legally speaking, is on IEBC to provide a free, fair, and verifiable election. There is no obligation on a voter like Hele Khalifa to hire and recruit agents all over the country to watch how the elections are conducted. If you do so, then you'll forever relegate the participation of the people of Kenya in a free and fair election to the ability to hire and deploy over 46,000 agents in all the polling stations to watch over their vote and the votes of others. The question was asked, the question was raised by Mr. Ngatia, that election officials are tired, they need to go back to work. Convenience again. I say this. Our constitutional values and provisions should not be sacrificed at the altar of convenience. If the election officials are tired and cannot do another election, please, We have more Kenyans who are willing to do this work properly. Give them that opportunity. And that ties to the point that was said, that Kenyans cannot be in elections in perpetuity. Kenyans must get it right. And I say this with due respect to this honorable court, that the Supreme Court has a higher obligation when it comes to this issue, to ensure that we get what we call regime legitimacy. In countries like DRC, once a presidential election is concluded, it goes to their Supreme Court, the Constitutional Court, to get a validation, regime legitimacy. That is what Helef is questioning here. In a fractious society, highly political like this, just remove that, highly political like this, a Supreme Court's decision gives regime legitimacy to that new regime. And when questions are raised like we've done, then the Supreme Court, and when you consider the margin by which the purported declared winner has surpassed the victory, that legitimacy should not be granted by this court at this point. I want to address a few questions that were asked by the learned judges. Number one, by Justice Ibrahim, is there a lacuna in the law if we nullify, in God's grace, these elections? And, sorry, if we indict Wafula Chebukati? The answer is very simple. Article 142 of the Constitution, the president who is in office shall continue in office until a new one is sworn in. There is no lacuna in the law. The second point, Mr. Chebukati is not immortal. He could even resign from his office. Does it mean that this country can collapse if Mr. Chebukati resigned from his office today? No. Elections will still be held. We'll still have within our governance, we have a working parliament, we have a national executive, we have a judiciary. All these questions, all these issues can be addressed within those existing parameters. And when I say the president will continue in office, of course, within a narrowed mandate, but the systems and the functions of government will continue. The lacuna will not affect the people of Kenya. The right thing is to make sure that the people's voices are actually heard in a true, transparent election. My learned Chief Justice asked the question, why it took too long, why the commission did not announce the results from morning. To corroborate that there was actually peace at Bomas, we had a choir singing the whole night and the whole day. If there was violence as was being presented here at 3 p.m., what stopped them from announcing at night? Those remaining polling stations, constituencies. What stopped them from announcing those constituencies in the morning? The choir is my witness. They were singing, there was peace, and everybody saw that. The other question that was asked by learned Deputy Chief Justice about a dysfunctional commission, I wish to say this. The dysfunctionality of the commission has always been there. But it has been brought to us by what I call a celebrated group in this constitution. In 2007, Kipkirui, an individual clerk, came out and told us what is happening at KICC is cooking. In 2017, Rosalind Akombe came out and said, what is happening at IBC is not being done in compliance with the orders of this court. And she ran away, she fled this country. In 2022, you now have the commission itself, by a majority of its members, coming out to tell Kenyans that what is being announced are not the product of the commission. Should those commissioners be vilified? Should a commission that has made an admission of a failure of Tier 3 be vilified? I say no. That dysfunctionality should actually now prove to you that indeed the Constitution is working. On the question that I wish the court to consider, what would have happened if we didn't have this court? In 2007, we didn't have this court. And those who had been said to have lost the elections didn't want to go to court when they were asked to go to court. Because to serve a president was almost impossible. the hearing of the petition will have taken forever, even 5 years, the entire term. This court should not leave Kenyans in a way that they start questioning themselves, do we still have an avenue through which we can solve these political questions? That is a core function of this court. If the court fails to stand up to occasion, the ramifications on the people of Kenya will be dire because people end up losing trust. So I urge you that do not err on the side of convenience to tell the people of Kenya that when we can see some of these problems, convenience requires that Chebukati cannot conduct an election within 60 days. Let us not upset the elections. It will erode public confidence in this particular court, which will be catastrophic as we witnessed in the year 2007. Tied to the commissioners, there are affidavits, and I believe the commissioner will talk about them. In their reply, the majority commissioners in their replying affidavits have already, we must point out, number one, that these commissioners have been in office for less than 1 year. September marks their first year in office. Within that 1 year, they've filed they've written 3 memos on the conduct of the chair unilaterally making decisions. Ultimately coming out on the 15th to tell Kenyans what they had been dealing with internally over unilateral, arbitrary, all-knowing chairman. And I say this as I conclude, my lords and my ladies. When an alligator comes out of the water and tells you that the crocodile is sick, do you doubt him? When the commissioners come out and tell you that our processes are opaque, our processes are not as per the Constitution, do you doubt them? I urge you, don't doubt them. We pray, my lords and my ladies, that you allow the petition as prayed and grant the orders which are sought, and don't shy away if you find it necessary to indict Mr. Wafula Chebukati for the transgressions and the singular manner in which he has run the IEBC to the detriment of Kenyans. Thank you very much, my lady. I yield today 13 minutes of my time back to court. 13 seconds.
Thank you. Counsel representing the 5th petitioner, David Kariuki-Ngare. 15 minutes.
Your Lordship, the Chief Justice, Deputy Chief Justice, members of the court, may it please you that my name is Mamboleo. I represent the 5th petitioner in the consolidated petition. We will be making this rejoinder together with my learned friend, Mr. Murara Umoke. Your Lordship, when we filed this petition, the response we got from the respondents was that this petition was frivolous. The other response, my ladies, my lords, was that the tallying, verification, and declaration of results at the National Tallying Center is a preserve of the chairperson of the commission. That the rest of the members of the commission have absolutely no role whatsoever. I can quote my senior colleague, Mr. Kamau Karori, as deliberately insisting that the other members of the commission, the 6, don't have a role. That in fact, the chairperson of the commission has been extremely magnanimous because at various points in this process, he's even involved them somewhat. The third response we got is that the election of the President of the Republic of Kenya is just about numbers. It is numbers, numbers, numbers. And then lastly, the respondents wanted to put this court in a dilemma, a catch-22 situation, by suggesting that should they exercise some powers under Article 140 of the Constitution and probably nullify the election, we are going to get into a situation that is uncharted constitutionally. Create fear. Your Lordships, your ladies, I want to suggest to this court when you retire, to look at what we call the theory of false dichotomy. The theory of false dichotomy is an informal fallacy that is based on a premise that erroneously limits the options that are available. And what the respondents are telling you is that the Constitution does not provide mechanisms to deal with the situation that might arise for something that is expressly provided for under Article 140 of the Constitution. I also want to suggest to you, my ladies, my lordships, when you retire, to look at what came into the open about 3 years ago, which is called the CIA Rule Book on Disruption of Organizations. How do you disrupt organizations so that you do not have an organization working as it should? And when you have achieved that, then you come out and use the law to subvert the will of the people. On Bomas on the 15th of this month, of August 2022, it is now judicially noticed that the beaming of results stopped. It is now in public notice that commissioners of the commission, at least for them, came out and stated that they do not have anything to do with the result that was being announced. It is actually admitted that as this was happening, top in the mind of the chairperson of the commission, he knew and understood the process of tallying, verification, and results to be his own preserve. He's not even refuted it. He says that is how he understood it. He said that the other commissioners had no role. So what do we want to suggest to you, your lordships, your ladyship? It is a very simple thing. That the reason why Kenyans were so glued to the television sets for almost 6 days is because the election of president is the only one thing that Kenyans do as a collective every once in a while. It is so important to them that you simply cannot joke about it. The reason your lordships and every Kenyan was glued to media stations for the 6 days is because you wanted to know what happened to your vote. So Article 138(3)(c), as read together with Article 38 of the Constitution, is, in my view, an expression of the greatest protection or the greatest gift that this Constitution has given to the benefit that is promised in Article 1 of the Constitution, that the people are sovereign. But if somehow you manage to capture the sovereignty of the people and set it aside by some scheme or something, then we are in a problem. And without taking too much time, because I associate myself with the submissions made by my learned senior counsels here, the important thing that we want to suggest to you, your lordships, is that when you retire, could you kindly borrow something that I know you already know, that Article 138(3)(c) of the Constitution is the ultimate protection that Kenyans have been given with respect to the presidential vote in a presidential election. And if you do so, then I'm sure you will come to the conclusion that Article 138(3)(c) is a peremptory norm of the Constitution. It is a jus cogens norm of the Constitution from which no person is allowed to derogate. Not the IEBC, not the chairman, not the President of the Republic of Kenya, and by no means, not even the Supreme Court of the Republic of Kenya. That this court must enforce the fact that this is the highest Grundnorm with respect to the protection of Article 38 and by extension, the sovereignty of the people of Kenya. I will yield my remaining minutes to my colleague, Murara Omoke. Thank you.
Good afternoon, Madam CJ and Honorable Justice of the Supreme Court. It's a great opportunity to appear before you once again this year. In quick rejoinder to some of the issues that were raised by the respondents, I'd like to urge the Supreme Court, when you retire to make your determination, to consider the historical context under which we operate, under which you make your decisions. The historical context is very simple, that in the last 30 years, you cannot identify a lot of instances of free and fair elections, except in the year 2002. And that one is there in history, that this is the only election that we've ever had in 2002 when there were no contestations between the winning and the losing side. But any other election outside of that, we've always had complaints coming out of those elections. And I wish to take this opportunity to urge you to use this opportunity to bring to an end what is becoming now a perennial problem to our nation, where we cannot talk about a free and fair election. It is very simple. When you look at this particular election, it's very surprising that anyone can tell you that there was no problem, unless they live in the Republic of Utopia. Anybody, even the children, our children, can tell you that there was a problem because they would see that the results were not coming out. We were waiting for the outcome for a long time. And in the end, whatever was announced left many questions. And this brings me to the test that should apply when you make your determination. The proper test to apply is the constitutional test when you sit to determine this petition. If you find any form of constitutional infraction, then you must nullify this election. There have been multiple infractions, very serious. And the question that must linger in the minds of the judges is whether you can trust the outcome of an election that is conducted by what I could simply call the Tower of Babel, because the IEBC, when you have two factions of an independent commission, that is something so serious. It should concern not just the judges. I was happy when I heard Madam CJ, you said that you are very concerned by that. And I pray that you continue being concerned by that as you retire to make your determination, and that all of us in this country be concerned by that. That we had a commission that has two factions, that is run by what has been described as an executive chairmanship. I was very shocked. I could not believe what I was hearing today. And this was being said by counsel, instructed by that chairperson to come and tell you that he is an executive chairman. You should not accept that kind of description. It's not provided in any way in the Constitution. You read Article 88, which establishes the IEBC. It establishes a commission, not a chairmanship. Article 249 of the Constitution, it establishes independent commissions, and it requires that these commissioners act independently, and they should not be under the direction of or authority of anyone, including the chairperson of any particular commission. The 7 commissioners, each of them independent, they are not to be held hostage, as they have been held hostage by the chairperson, who says he's an executive chair, and who not only says that, but also instructs his advocates to declare him a national hero. I think that is ridiculous. In my opinion, if there is any heroics that we should be applauding, all of us, is the 4 commissioners who are courageous for their courage, that they came out and said there is a problem. Because in this country, we must learn to speak up, we must speak out when we see a problem. And on my level, as an individual, I applaud them. And I think that what we should be applauding, we should not be praising things that are seen as unconstitutional. Very quickly, I would like to highlight other provisions of the Constitution that I think that should be looked at very keenly, and there was no compliance with that, which should lead the court to determine that there was no free and fair election. Article 10, was it fair and transparent? We cannot say that, because if we have a result that has been tallied and verified by a few commissioners, and the majority of the commissioners are not given the opportunity, or we have some results that were not verified, then how can we say that that's a fair and transparent election? I ask you to look at Article 81, the general principles for the electoral system, which talk about a free and fair election. that is run in an efficient manner, that are free from any corruption. But we've had many shocking things that in our country, we can have foreigners, even from the failing states, taking advantage of us, our systems, our people, and our electoral system. And the court should rebuke that kind of a thing. We should not allow it to happen again. It's a shame that, indeed, this is making us a laughing stock in the world. Everyone is laughing at us that we cannot carry on our own processes, simple process of tallying results and declaring them. That there's always a problem. When we could see the IEBC spending more time entertaining us with their music, instead of announcing the results. It was very irritating, I must say, as a voter, when you cannot find the results from the commission, but you find music that you could play very freely on your own devices if you wanted to. Article 138(3)(c) is very clear. It has stated that the role of verifying, tallying, verifying, and announcing the results is vested in the commission. 138(10), by referring to the chairman as the one who is declaring the results, is simply delegating that responsibility to him. And even if the chairman was not there, that function would still be carried out. If you look at the IEBC Act of 2011, Section 7A and B, it clearly provides what should happen in case there's a vacancy in the position in the office of the chairperson of the IEBC. Things will go on. Nothing will stop, as the chairman would like us to believe. Everything will be carried on, even if the chairman was not there. And should this court find it appropriate to declare that there's an element of breach of Chapter 6, the court should go ahead and make that determination, and other processes can follow. As I close my presentation, because I have 1 minute, I would also like the court to consider very carefully whether we indeed have the threshold to declare a candidate as having won this election. As we speak now, we cannot determine whether, we are not sure about the total valid votes that were cast in this election. And without that, we cannot determine whether we have a 50+1 threshold. And I ask the court to look very carefully. In my opinion, we do not have that. There's a lack of clarity. Mahat's presented figures, which I would say many of them were based on presumptions and projections. And that's not what the IEBC should be doing, not giving us projections. That is for the analysts to do. Independent analysts can give us projections, but for the IEBC, they must give us specific figures. They cannot give us figures that are merely projections or made up based on presumption. The figures of how many voters were astray, how many ballots were astray, should be verifiable. I urge you, my ladies, and when you sit to deliberate, let's make things right for our country.
Madam Chief Justice, kindly permit me to seek your guidance. I also appear in the same matter. There were some two specific questions that were put to me by Justice Lenaura and Lady Justice Jokindungu. I will only take 3 minutes and attempt to answer them. Madam Chief Justice, the question was put to me to try and link my arguments with the issue that we are canvassing here in respect to the number of the constituencies that must participate in a presidential election. To attempt to answer that question, Madam Chief Justice, permit me to refer the court to Article 136 of the Constitution, which provides that the president shall be elected by registered voters in a national election conducted in accordance with this Constitution and any other act. That election, the directive of how that election is to be conducted, my lady, is found under Article 138, Clause 2, which provides that if 2 or more candidates for presidents are nominated, an election shall be held in each and every constituency. And therefore the question is, the use of the word or deliberate use of the word constituency is deliberately used by the Constitution, and these constituencies are determinable. And if you want to determine these constituencies, you therefore go to Article 89 of the Constitution. You also further go to Section 2 of the Election Act and see what defines this particular constituency. Why is it important for us to factor this in? It's because any voting that was done outside the Republic of Kenya that is not contemplated by Article 5, which defines the territory of Kenya, then any vote that was cast is an illegal vote, is an invalid vote, and it is a vote that goes towards contaminating the election. Further, my ladies, my lords, in answering the same question, the constituency that was defined by the chairman makes us to have 291 constituencies, completely out of the realm of the Constitution. And that is the illegal infractions we are saying that the election has been infiltrated with. My ladies, my lords, when you are applying these arguments, or considering my argument, consider that you held in RAILA 2 that under Section 83 of the Constitution, if any of the issue, either be it legal or factual, is proved and ascertained, then that issue can void an election. The question of the constitutionality of that one extra constituency is an issue that contaminated this election, and it's an issue that should be factored and should not be lost in the eyes of this court. Finally, allow me to sum up by saying that Thomas Paine quoted and said, "A body of men holding themselves unaccountable to nobody ought not to be trusted by anyone." If IEBC does not hold itself accountable to anyone, then who should trust them? Can we even trust the processes under which they have taken through this country? I bet not. I beg to rest. Much obliged.
Next is counsel for the sixth petitioner, Okiya Omtata and others. 15 minutes.
May it please you, Madam Chief Justice, Madam Deputy Chief Justice, and members, honorable members of the Supreme Court, I wish to respond in 15 minutes, which I shall share with Mr. Okiya Omtata to break down the figures to show that the threshold under sub-article 4 of 138 was not satisfied because the numbers simply don't add up. But I will make a few remarks, Your Ladyship, because there are a few questions that I needed to respond to as well. It is now clear that the ipse dixit of the petitioners on the question of compliance and non-compliance of the Constitution is now sound. And clearly Articles 81 and 86 are in question on compliance. The respondents, my lords, have put up, the second respondents have put up a self-righteous and pompous response on the question of the role of the chairman. And I want to just respond in this manner, my lords. Section 5 of the IBC Act defines what a commission is. And a commission is defined to include the chairman of the IBC and the members. That definition, my lords, contrary to the submissions by Mr. Karori, senior counsel, does not include and expressly excludes the staff of the commission. It cannot therefore lie in the mouth of counsel to submit that the verification and the tallying of the results of the presidential elections, insofar as Form 34As and 34Bs were concerned, was done by the staff and excluded the commission, who were confined to other duties. My lord, that was a violation and an infraction that expressly went against the requirements of Article 138, 3C. Secondly, my lords, the submissions by learned friend, senior counsel, Professor Githu Muigai, on the executive status of the chairman of the IBC, I think should be taken with a pinch of salt. Because
Article 249(1) of the Constitution does not contemplate an imperial chairman who is all-fearing with fear, favor, fervor, and fiat. That is not the chairman that we have. The chairman of the IBC, appointed under Article 250 sub-article 4 of the Constitution, must be that chairman who is a first amongst equals, just like the Chief Justice of the Supreme Court. A primus inter pares who must work with his colleagues to guide the affairs of the Commission. I urge the Court, therefore, to decline an invitation by Professor Githu Muigai that the chairman of the IBC is in a special position, different from the 4 commissioners who are crying aloud to be heard by this court. And my lords, this petition, petition number 5, as consolidated, therefore tilts on the violation of Article 138(3)(c). It tilts on that violation. And that violation alone, my lord, therefore invites this court to look at or to turn to Articles 23 of the Constitution on your role as a court to interpret the Constitution in a manner that goes beyond just protecting human rights, my lords, but to look at what would guide your interpretation, the holistic approach, the purposive approach, and let me borrow my learned friend's approach, the Antonin Scalia's approach, the late judge of the US Supreme Court, the textual and the contextual approach. And if you apply those approaches, my lord, then you will find that the chairman of the IBC, in failing to properly construe his role under 138(3)(c) and 138(4), violated the Constitution, and an unconstitutional process therefore emerged that cannot put into place, my lord, a process that violates Article 3(2). My lords, there is an invitation to you to invalidate the entire process. And that is why in answering in answering the Supreme Court judge's question that was directed at me on remedies, I wish to state that, and this is because this court also has a purpose under Section 3 of the Supreme Court Act. And given that you're an election court under 84, in an ideal situation where you are construing Section 83 of the Elections Act, which must be interpreted disjunctively, because if there's an unconstitutional act, then the election cannot stand. If quantitatively, as we shall demonstrate, there is non-compliance, again, you'll have to invalidate the election. But my lord, in an ideal situation where you'd have been called upon to apply Article 232 on public service and Article 201 on public finance, you would have ordered a recount and then secured a winner. But this would only have been possible if there were no unconstitutional infractions that undermine the process and therefore make it unconstitutional. Because this is no longer about tallying and verification. It is about the bigger process of the involvement of commissioners and a split commission. And the only remedy available, my lords, Justice Ouko, the Chief Justice and member of the court, is a nullification. This is no longer the baby of Raila Amolo Odinga V. This is no longer the baby of William Samoei Ruto, Dr. the First Respondent. This is the baby of Wanjiku. It is the baby of Kenyans. Return this baby to Kenyans to determine to whom they shall hand over the baby after 60 days. I pray that you nullify the election. And I will cede my time now to Mr. Senator of Busia County, Okia Omtata, the perennial litigant. Thank you.
Distinguished honorable members of this court, I'll begin my submissions by requesting that my PowerPoint presentation be played.
Just to respond on points of law.
My lady, there was a question that was posed by Justice Ouko.
Yes.
To which Mr. Mohammed answered.
Okay.
And I would like to make a clarification on that. On the points of law, I think Professor has covered.
Okay. So you're only answering the question by the
yes,
court?
Yes, my lady. Could the time be stopped, please, so that... Yes, we are going to interrogate the figures that were used here to attempt to mislead this court. I'll begin by asking the officer to play the slide number 6. That slide that contains results, when I looked at it, and my other co-petitioners, we found that the maths did not add up. And that for us, and I would also ask the court to realize that the comments we made about that particular result have not been challenged. That when you add the totals for the individual parties, you don't get the total ascribed. But the total ascribed is available in the workings and the affidavits of the members of the commission, which means we are dealing with fiction. I would request that you go to slide number 5. And another thing. So when we had 21. Returns which had been made, average number per voting station, we were told we were polling stations. If you divide 22,120,458, far from when you take 65% of 700, which is the maximum. So when you now come and using the 478, which is the average we have had, and divide 21,481,652, you get 44,000. Bukat is replying affidavit. The figure he gives is that 45,994 kids reported. Now, from this, you already see that if the kids were 46,994 had reported, had connected, so the question of saying that these kids were looking for connection is not there. These kids were connected and they discharged their mandate. Some kids in Eldoret were wherever, one kid being used. The 305 kids, which may not have had network, by the maximum, the 700, if you multiply that, you'd get a figure of about 213,500 votes. That's the maximum that could be transmitted, not 2 million votes. $1,337 kids could get is 6 are not these ones that the fact that they held so much data was mined remotely, mining the data that was already reported in these polling stations. And that's how the fraud happens. For the workings on slide number 2, where you can clearly see that if we use the 21,481,652 as the baseline and the 12,065,000, you find these workings coming out, and you can see that on. But most important, even if we were to buy the idea that they were connecting, you have got 508,647 ballots on page 3, slide 3, which transmitted after a period of 3 hours and 45 minutes. So those particular transmissions of 508,647 are a figure that's very curious, because if you deduct the tally for Eldas from this figure, you hit almost the exact figure that Mr. Willis, Land Council Willis, has presented to this court, coming from the KPMG audit, that there was that number of voters, there was a number of ghost voters equivalent to that one. When we go to the other thing that supports our position, there was a question of what was the denominator used for voter turnout. I will invite you to look at at the petition at page 41. There's a letter, a press statement signed by Mr. Chebukati, saying that he used the National Voter Register to calculate, and if I may just read it quickly to the court. So page 41 is handwritten 41. It says, paragraph 2, at around 4 p.m., 12,069,803 registered voters out of 12,065,803 voters out of 22,120,458 had cast their vote. This equates to 56.17% of voter turnout.
How much do you need? Because we have that slide. Could we give you 2 minutes to finish?
Here that you will refer to the slides. So, when I look at that, you'll find that there's no basis for claiming that the figure that claiming that the Kim's kits were used as the denominator. It's not possible, and it's not there. Also, I would like this court to take note of how the percentages are being played with. That's slide number 10. You'll find that whereas the chairman is reported 12,065,803 people voted, who voted represented 56.17 of the total registered voters of 22 that. At paragraph 26 of the replying affidavit, Mr. Sunkuli, using the same number of voters, 12,065,803, but as reported by the chairman, but again as a different number, as a denominator, he arrives at the same percentage. So there you can see how they can play with numbers by changing the denominators and arriving at magical figures. So my members of the Honorable Court, my prayer is that my submissions are that these figures are cooked, they were worked backwards to achieve a certain figure, but fortunately, on the Form 34C, the smoking gun is seen. And since Figures don't lie. And if the math doesn't add up, then this court should quash the results. We were told about military precision. Military precision is the ability to shoot a bullet with a bullet. That's how a missile downs another missile. That is not what we are saying here. There's no military precision in these figures.
The last petitioner, seventh petitioner, Julia Nyoka Bichege, and others.
May it please you, Melody, Madam CJ, and other members of the court, to go straight to the issue. I've had a lot of Shakespeare and other learned fellas. I went to public schools. I may not be able to remember anything about Shakespeare. But Madam CJ, besides a Greek philosopher known as Plotinus and Adam Smith, my favorite philosopher is called Karl Marx. And one of the most famous quotes that he made is this, that history repeats itself, first as tragedy, second as farce. Now, I go to my issue. Yesterday, Madam CJ, when I was listening to my learned colleague, Mr. George Oraro, Senior Counsel, I could not fail seeing the echoes of 2007 in what is happening today. Madam CJ, in 2007, the secretary to the commission, just like this year, was at the heart of what happened. The secretary was called Suleiman Chege. The secretary today is called Hussein Marjani. Same problem of numbers. The Kenya law reports would bear, and Mr. Isa Mansour is also here, that I represented Samuel Kivuitu and others when they were removed from office. Now, it turns out that, and listening to my learned colleagues, that just like in 2007, the person who knew why the results are like that was Suleiman Chege. Listening to the presentation yesterday, it also appears that the only person who really can tell us about these numbers is Hussein Marjani. Second similarity is that both Raila Odinga and William Ruto were at the heart of what happened in the year 2007. But that is not the more important point. The more important point is the differences. The differences were these. In 2007, and under the constitution that was existing that time, the election was announced on the 30th of December 07. And the president sworn on that day assumed office. But the difference this year is this. After 15th courtesy of the new constitutions, on the 15th of August when the declaration was made, the person designated as the winner by Chebukati became president-elect. That's an important distinction. The second most important distinction is this, that the former constitution of Kenya did not have an equivalent of 138 of the constitution. There is that distinction today, which is what I was calling stage 3 of a presidential election. It was never there. The next issue was that in 2007, the presidential elections were held by the High Court under its original jurisdiction and special jurisdictions of elections. This one comes to the Supreme Court, and the basis upon which that is done is on the basis. There is no sitting president who will be appearing before you. There is only a president-elect. Now, my first petitioner, Julia Chege, asked me, because there was a subjective question that was posed in her view by Judge Smoky Nwanjala, that how come there was no protestations by these people when they were being given domestic chores? According to Julia Chege, who had to resign from her university job as a lecturer, there is something that needs to be understood. The human population, you want to follow the natural order of things. You don't disturb things. You let them things as they are. You must understand that from your point of view, a lot of you and she an opportunity. The four commissioners for ultimate have something to stand for. They are heroines and heroes of this country. We come now talking about heroes to what my professor of criminal law and procedure, Dr. Gethu Muigai, said. Dr. Muigai, looking straight to the face of this court, said two things. A, the problems in our elections is not IEBC, but the candidates. History does not support that conclusion. Second thing he said, B, Wafula Chebukati is a national hero. I don't have to say anything on that. Now, Madam CJ, there is the issue of the word independent, or in the designation of IEBC. The word independent, it is further elaborated by under Section 26 of the IEBC Act. It says IEBC is independent, but shall be subject to public participation and to engage stakeholders in the discharge of its mandate. Madam CJ and members of this court, I flatter myself quite often that I have a reasonable understanding of Kenya's electoral laws. However, Madam CJ, listening to my learned colleagues yesterday, I had a lot of reasons to doubt whether that is true if what they said is actually the true representation of the law. And in several senses, under Article 81, the election should be simple, accountable, accurate. But until yesterday, my understanding was this, that reference to the Commission and Article 81, 86, 88, and 138 of the Constitution triggers the image of Chebukati and 6 others. I've never imagined Marjani and other returning officers when we talk about the Commission. B, based on Sections 10 and 11 of the IEBC Act, my understanding has always been that the Secretary of IEBC is the chief executive, the head of the secretariat, the main employee of the commissioners, who appoints him. But now it appears to be that for purposes of a presidential election, and we heard it from his lawyers, he's actually the main man. Was this what the Constitution wanted it to be? Welcome to the Republic of Kusadikika. I must agree with my learned colleague, Mr. Muthomi Kiathiankulu, that it would appear that since we did our elections, we became some kind of a terrestrial Kusadikika, and several questions arise. When, why, and how? When did this happen? It first happened just before midnight or 9th of August, when we retired to bed. One figure we ought to have had was not known. How many of us voted? That is the when. How did it happen? It happened because on the 8th of August 2022, Wafula Chebukati published that Gazette notice that I talked about. On the face of it, makes the chairman a dictator. No, that is not the issue. If you read it as an instruction manual, it was to give the job to Hussein Marjani. That is what happened. Why did it happen? It happened, and we explained in our affidavits, paragraphs 42 to 45, And what they say that effectively, on the 15th of August, when these elections were declared, from 7:30 to 6 p.m. on that day, the commission, as the commission, had lost effective control under Article 138 of the Constitution. I come, because I'm trying to rush myself, to the petition, number 7. This petition, Madam CJ, is actually a numbers petition. I didn't want to make a lot of fuss that I would have needed more time, but in case my mouth does not go fast enough, I urge you that you give me a little leeway to conclude what I need to say. The issue is this, Madam CJ. When you pose the question that you posed, how do you have evidence 700,000 people did not vote? You triggered some kind of public participation on my phone. I had many calls. Kipe, why did you just say it's 700? It's about 3 million. But of course I had to tell them, no, we just say it's 700 because we had some kind of evidence. So it's a big issue, Madam CJ, that you triggered a public participation. So many people don't vote on account of non-enforcement of Regulation 90 by IEBC. Now, for whatever the value is this. I can demonstrate very shortly, and we've done that in our petition and in our, in our affidavit, that when you have a petition based on non-compliance, how do you prove it? We have an affidavit of Julia Chege that basically has not been, has not been controverted. She says where she was voting. She was voting as an MP she was contesting the office of Kangema. And she said how she interacted with election officials. There were no affidavits sworn by the commissions to say those interactions she talked about were not true. But more importantly is this. When you say Regulation 90 says you are going to publish notices on how election officials and security officers are going to vote, IEBC needed to do a very simple thing. Namely, what did you publish to implement it? If you didn't publish anything to implement it, you are responsible for non-compliance. How do you treat non-compliance? You tell the Supreme Court. We could not be able to have non-compliance for reason A, B, C, D. Then the Supreme Court may decide to excuse you or not. But in the absence of that, non-compliance has been proven. What is the effect of this non-compliance? We have stated in our further affidavit, it's a numbers thing. If 700,000 people did not vote and you adjust it whichever way you want, you will still have a figure of 300,000. So that the long and short of it, my ladies and my lords, is this. Unless you excuse IEBC, and they did not ask you to excuse them, then you must find that the numbers in petition number 7 could have altered if those people had voted the results of the general election. And therefore, it is not permissible for anybody to be able to say, oh, it's a numbers thing. Petitioners brought no number. We brought numbers, and there was no response. We come to the issues of the issues of the procedure under Article 138. Under Article 138, that's one of the best done judgments that I've read. I've read it many times. It was written by artist Judge Jouko was there writing it. Catherine Mantoinoti was there. He was my pupil master. One of the best written judgments. I've read it many times. But yesterday, it somehow appeared, I don't understand these things. So I read one more time yesterday night. And I thought, I think I understand what it says. So it was violated in 3 major ways, my lady. Number 1 is this, issues of the voter turnout. The issues of the voter turnout until yesterday, I thought is usually settled before the elections through the gazettement of a voters register. For these elections, it was done on the 21st of June 2022 through Gazette number 7290. But listening to my learned colleague, Mr. Somane, it would appear that very educated people like James Orengo, Firoz Noroji, Paul Mwangi can actually write petitions, and they were told in open court they did not understand what is all this about Article 190. And I also shuddered that if they didn't understand, probably I also did not. The second failure is this. In short, I'm saying the register cannot be mysterious. If the register is mysterious, the election is not simple, does not meet the requirement of Articles 81 and 86. Number two, the stoppage of the public display. I didn't hear a straight answer to that. Now that there was no straight answer to the issues of the failure of results, and the 27 were not read, that goes straight to the root of the procedure under 138. If that was not done, my lords, there is no way in which you can be able to say the election was valid. For a simple reason, which is this. That when, can I have 2 minutes? 2 minutes. Yes, I can read in 2 minutes. For the simple reason that we were dealing with under Article, for the conclusion, the whole point about Article 138 is that the procedure must be concluded. If it is disrupted, you have to hold that Article 138 was violated. The next issue is this, the third one. We talked about the issue of effective control. If you are convinced by what you have heard, and we have gone through this in the last 2-3 days, that IEBC lost effective control from 7:30 on the 15th to 6 p.m. when the results were read, there can be no basis for this court to say anyone was validly elected as president of Kenya. My learned colleague, Mr. Fred Ngatia, whom I respect a lot, said that William Ruto won these elections fair and square. That expression, fair and square, to my mind, comes from, as I understood, the famous judgment where Judge Madan was in the Githunguri case, where the basic point was this, that certain issues may happen that may make even a person who on the face of it could have been liable for criminal offenses not to be properly tried. And therefore they said it makes any conviction to be bad in law. You do not have a fair and square deal. Under Article 138, Raila Odinga, the other surrogate petitioners, they need a fair and square deal that their votes were not enough. Finally, my lady, the Chief Justice, Article 138 must not die in your hands. We are most obliged.
I think that brings us to the end of... Yes, that brings us to the end of Rejoice. We are looking at Senior Counsel, Mr. Mwite, but we know very well your clients were respondents. It was only for the under-representation that we allowed them to come just after the petitioners. They do not have a right of rejoinder.
Chief Justice, I am acutely aware of the time constraints within which this honorable court must adjudicate on this petition. And may I say that this honorable court is entitled, suo motu, to decide that the 14 days specified in Article 140 mean 14 working days. Yes, to exclude Saturday, Sunday, and public holidays. You can do that, you mortal. I am pleading, Chief Justice, I'm pleading on behalf of the 4 commissioners. I plead. They have had very, very little time in this court. I plead.
That is why I was looking at you with the questioning eye, because
Yes.
there were some questions also which were asked, and they need to be responded to.
Yes, those are the ones. I'm just pleading.
Yes.
Allow my colleague Mansu Issa some 8 minutes, and Dr. Arroa some 3 minutes, and yours truly some 2 minutes only.
That is 15 minutes.
Because, yes, because...
To answer those questions.
No, because, Chief Justice,
Yes.
those questions directed at those 4 commissioners are very important. And
Thank
when
you.
others were answering questions,
Yeah.
a lot of maligning, a lot of... Please give them that opportunity to have their case stated. They are the
Okay.
majority in that commission.
Thank you, Senior Counsel. I
thank you.
think we've heard your plea because we asked questions. So we'll give them 15 minutes to answer, not now. We want to take a break. And immediately we finish, there was an issue raised by Senior Counsel Gatia responding to some 2 Forms 34, and you asked for 5 minutes. And then we will give the parties 15 minutes, not all the parties, the ones who are connected with the discovery and the scrutiny, 15 minutes in the afternoon to respond to the report.
I request, Madam Chief Justice, may I request 5 minutes for the Commission, because we are the custodians of the form, the legitimate forms.
Yes.
And my learned friend, Mr. Orengo, needs his lunch now. He's heckling.
Okay, we'll give you 5 minutes, and the court will arise.